Hello, I'm Jaspreet on this side. I'm company secretary by profession. And now let's start with our 10th video on revision of Companies Act 2013. In the ninth video, we had discussed about charges, registers, annual return, and AGM, annual general meeting. And now in this 10th video on revision of Companies Act, we will start with extraordinary general meeting. Disclaimer is that this is only for revision purpose, just to brush up our memories, and for practical application please refer updated laws. So let's start with calling EGM, Extraordinary General Meeting. Section 100 relates to EGM, Extraordinary General Meeting. The board shall call EGM on requisition made by. So a requisition is to be made for calling an EGM. AGM is mandatory to be called once per annum. However, for EGM, a requisition is to be made by either by shareholders holding not less than one-tenth of paid-up capital in case of company having share capital. So shareholders holding not less than one-tenth of the paid-up capital means if they are holding equal to one-tenth of the paid-up capital means 10% paid-up capital. Here what is capital means including equity with differential voting rights and preference shares. So complete capital is to be considered. One-tenth of complete capital is to be considered. Such number of members having not less than one-tenth of total voting power of all members in case company is not having share capital. So either it is one-tenth of the total paid up capital or one-tenth of the total voting power. Such shareholders can requisition for calling an EGM. Period of holding EGM. Now, if board within 21 days from the date of receipt of requisition does not proceed to call EGM on the day not later than 45 days of receipt of requisition, meeting may be called and held by requisitionists themselves within 3 months from the date of requisition. Now let's break this down. First, a requisition is received that a meeting be called and one-tenth of the shareholders means total paid up capital or voting power have requisitioned. So the company has received the requisition. Now, within 21 days from the date of receipt of such requisition, either the board holds a meeting itself or here because for meeting generally we have to give 21 clear days notice. So within 21 days board need to proceed to call an EGM. How we can see that proceeding an EGM has initiated? That if within 21 days board issues a notice of EGM providing date and place when EGM is to be held, then also it is proceeding, board has proceeded to call EGM. Board has proceeded to call EGM. That proceeding should happen within 21 days from the date of receipt of requisition from one-tenth of the total voting power or total paid up capital. Now, what happens is when within 21 days it will proceed to call a meeting on a day when this EGM should be held. This EGM should be held not later than 45 days of receipt of requisition. So initiation will happen within 21 days, but maximum time duration within which an EGM should happen is 45 days. So from a shareholder's perspective, once a requisition is made, then a shareholder can expect that if the requisite number of shareholders have requisitioned for holding an extraordinary general meeting, then shareholders can expect that the meeting will happen within 45 days of the date of requisition. And in that 45 days, within 21 days, board has to proceed to call the meeting, means send out a notice for EG. Now, receipt of requisition meeting may be called if this is not done. Next scenario is that Requisition is sent, 45 days time is over, no meeting has happened. Okay. Or notice is sent, 21 days is over, but no proceeding, no action of calling an EGM is seen from the side of board. So after requisitioning, if within 21 days no notice is seen of requisitioning a extraordinary general meeting, then the requisitionist can themselves proceed to convene an extraordinary general meeting. So then what will happen? Then a meeting may be called and held by requisitionists themselves within 3 months from the date of requisition. So board had power to convene a meeting within 45 days of requisition. If within 21 days of requisition board do not respond anything, then the requisitionists themselves can proceed to convene an EGM. That EGM should happen within 3 months from the date of requisition. Total time duration is 3 months from the date of requisition. Here, months is important. The total tenure is 3 months if they themselves are proceeding. Otherwise, for companies, time period is given in days, 21 days, 45 days. Place of holding EGM. EGM of a company other than the wholly owned subsidiary of the company incorporated outside India shall be held at a place within India. Okay. So EGM of a company other than wholly owned subsidiary of the company. A company, generally a company which is not wholly owned subsidiary of a foreign company, of a company incorporated outside India. EGM shall be held at a place within India. Ideally, EGM shall be held at a place in India. However, if the company is subsidiary of a company which is incorporated outside India, then EGM may be held outside India also, provided the holding company is incorporated outside India. Okay, holding company is outside India, then EGM can be anywhere. Otherwise, EGM should be held any place in India, and EGM can happen even on national holiday. The restriction of national holiday, that the general meeting will not happen on a national holiday, is applicable only for annual general meeting. Clear? Now, EGM related section was section 100. Section 100 related to calling an EGM by requisitionist. Now, notice of meeting. Section 101 provides that notice of the general meeting should be served to whom notice should be served. Notice should be served to the members, obviously. The members will be served. Number two, legal representative of a deceased member. If a member is dead, then his legal representative will be served with the notice of the meeting. Assignee of insolvent member. So if a member is declared insolvent by any court, then in that case, the assignee, which was disclosed to the company that now this person is the assignee of the insolvent member's estate, then that assignee is the person to whom notice of AGM general meeting is to be sent. Auditors of the company. Notice of general meeting is to be sent to the auditors of the company. Every director of the company. Notice of general meeting is to be sent to every director. So primarily members or legal representative of deceased member or assignee of insolvent members, all three relating to members they have to be sent, no question about it. Then auditors and directors, these are the people to whom notice of meeting is to be sent as per section 101. Next is length of serving notice, 21 clear days. So the notice of a general meeting is to be sent with a 21 days clear notice. Excluded date on which notice is served. Excluded date on excluded. This 21 clear days will exclude date on which notice is served. So the date on which you have sent the notice, like if you are sending by post, then the date of post, receipt of post office, Then in case you are sending by email, then the date of EGM when notice is sent, that particular date is not to be counted in 21 clear days. Then plus 21 days. Then also exclude date of meeting. The date on which the meeting is to be held, that day is also to be excluded. So that in that sense we have to give 21 clear days. Clear days come to 23 days from, because the date of sending and the date of meeting are to be excluded. So these become 23 days. Plus if we are sending by post, then 2 days are also added again, which is provided here. As per Rule 35 of the Companies Incorporation Rules 2014, in case of notice of meeting when delivery is by post, such service shall be deemed to have been effected at the expiration of 48 hours after the letter containing the same is posted. So we will consider that delivery is made on expiry of 48 hours. 48 hours roughly comes to 2 days. 24 hours plus 24 hours is equal to 48 hours. So service will be deemed after 48 hours of posting. So that way ideally we should take a buffer of complete 25 days to count for the purpose of notice of general meeting. Next is meeting held at a shorter notice. Meetings held at shorter notice means less than 21 clear days. Meeting can be called at shorter notice if consent in writing or by electronic mode is accorded thereto. Now here word is not prior consent. So consent even on date of meeting can be taken. Consent request for consent can be sent along with notice of the meeting, which some people do in practice. So meeting can be called at shorter notice if consent in writing or by electronic mode email is accorded thereto. In case of AGM, in case of any other general meeting. So in case of AGM, by not less than 95% of the members entitled to vote thereat. So means if there are preference shares but they are not entitled to vote, then those will not be counted in these members. And suppose if dividend is not paid to preference shareholders, they have got the right to participate in voting on every resolution, then they will be counted. So for the purpose of AGM, lesser than 21 clear days notice is to be sent if consent is received. This is not a prior consent, but consent has to be received by from 95% of the members who are entitled to vote thereat. In case of any other general meeting, means in case of extraordinary general meeting, company having share capital, company not having share capital. So company having share capital, members having at least 95% such part of paid up share capital of the company as gives the right to vote at the general meeting. Similar. Then if not having share capital, members having 95% of total voting power exercisable at that meeting. So voting power is to be checked in case company is not having share capital. In case company is having share capital, then those voting 95% is to be calculated for both general meeting and for both annual general meeting and extraordinary general meeting. Next is types of business transacted in AGM. Types of business transacted in AGM. Okay. This is section 102. Section 102 provides for types of business that can be transacted. So we have ordinary business and special business. Ordinary business cover 4 businesses as given in next diagram. We already know about them. And special business, any other than these 4 ordinary business is special business. At AGM, all other businesses except the ones stated as ordinary business are special businesses. That is clear. Now what are 4 ordinary businesses? So 4 ordinary businesses are: number 1, consideration of financial statement and the reports of the board of directors and auditors. So this consideration of financial statements, which will include both standalone and consolidated financial statements if applicable, and reports of board and auditors. In case of consolidation, board report only relates to standalone financials. Then declaration of dividend, if any. If any dividend is to be declared, then that will be provided here. Then appointment of directors in place of those retiring. So if there is a fresh appointment of director, then that will be done in special business. If there is regularization of a director is here, but will he cease to be a director in this AGM? That can be considered regularization of director. And directors retiring by rotation. Directors retiring by rotation is applicable to certain companies, so that will be considered appointment of directors in place of those retiring. And last is appointment of and fixing of remuneration of the auditors. So these are only statutory auditors. If we are appointing and fixing remuneration of cost auditor, secretarial auditor, then that will come in special business. In ordinary business, we have appointment and fixing of remuneration of a statutory auditor. So these four are ordinary businesses, and everything else is special business. Special business will carry explanatory statement along. Okay. Quorum for meeting, section 103. This is relating to general meetings. So quorum, public company. In case of public company, quorum will depend on number of members. If the number of members is less than 1000, or if the number of members is equal to 1000. So if the number of members is less than 1000 or equal to 1000, then at least 5 members personally present shall form the quorum. If 5 members are not personally present, then the meeting will not start. It will have to be reconvened on the same date after a week, or as the date may be decided. And if in that also it is not there, then that will proceed as it is. But this is requirement that 5 members personally should be present. If total number of members are less than or equal to 1000. If total number of members are between greater than 1000 but less than equal to 5000, then 15 members should be personally present. And if this number of members is greater than 5000, then 30 members personally present should form the quorum for the general meeting. In case of private company, 2 members personally present is sufficient to form the quorum. 2 members personally present is sufficient to form the quorum. Proxies, section 105. Proxies. Any member of a company entitled to attend and vote at the meeting of the company shall be entitled to appoint another person as a proxy to attend and vote at the meeting on his behalf. So any member of company who is entitled to attend and vote, so that particular member can entitle someone else to attend and vote being proxy. And usually proxies can vote not through show of hands. So proxies cannot vote through show of hands. So proxies can be sent by only those members who are entitled to attend and vote at the meeting. Proxies shall not have the right to speak at such meeting, so they cannot speak at the meeting, and shall not be entitled to vote except on a poll. Means they cannot vote on show of hands, they cannot speak, they do not have right to speak, and they do not have right to vote except on a poll. A person appointed as proxy shall act on behalf of such member or number of members not exceeding 50 and holding in aggregate not more than 10% of the total share capital of the company, carrying voting rights. So a person cannot be proxy for more than 50 members. Same person can be proxy for up to 50 members. However, same person cannot be proxy for holding not more than 10% of total share capital of the company. Okay, so if say a member is holding more than 10% total share capital, say he is holding 11% share capital, then the proxy will be only of this particular person, and that proxy cannot be proxy to any other member. However, if this percentage is 10, still if he wants to, still if see if this is number is 10, then proxy can be appointed for other members also. Say 5 persons are holding 10% share capital each, who have right to vote also. Now then they can appoint same person, means a person can be proxy for 5 shareholders. But if a shareholder is holding 11% and more than 10%, then that proxy will only be a proxy of this particular shareholder. This is the concept which is being shared here. A proxy received 48 hours before the meeting will be valid even if the articles provide for a longer period. So law provides 48 hours timeline, that before the meeting, at least 48 hours before the meeting, the proxy should be provided to the company. The company will prepare register of proxies, and if proxies are received not before 48 hours, then that will be not counted for the purpose of proxy. Instrument appointing a proxy shall be in writing. So instrument appointing a proxy shall be in writing. That is all about proxies. So member can appoint a proxy, no problem. Proxy cannot speak at the meeting. Proxy cannot vote by show of hands. Proxy can vote only by poll. Then proxy can be of up to 50 members. However, a member holding more than 10% shares cannot, a proxy cannot be of more than one member who is holding more than 10% shares. Proxy should be received 48 hours prior to the meeting. Articles may provide more than 48 hours, but that will not be considered. What if articles provide 24 hours? So if articles provide that we will accept proxies even 1 hour before the general meeting, then that will be counted. But articles cannot provide timeline beyond 48 hours. Okay, 48 hours is the maximum timeline that cannot be breached. Means time to be given to members to give a notice of proxy cannot exceed 48 hours. It can be reduced. It can be lesser than 48 hours by way of articles of association of the company. Voting. So about voting, we have what we know all about voting. Voting can be by show of hands, clear, that usually happens. Voting by electronic means, we can provide this facility to the members to vote by electronic means. Voting by poll, we can provide poll papers where physical letter is sent, consent letter is also, draft consent is also sent, which has to be filled in and sent by mail or courier. Voting by postal ballot. So, oh yes, voting by postal. What I provided was voting by postal ballot. That physical resolution and a format of consent is sent, and the shareholder has to fill in and revert by courier or mail. So that is called voting by postal ballot. And voting by show of hands and voting by poll happens at the meeting physical venue, and there is concept of voting by electronic means, which is mandatory for listed companies. Even postal ballot is mandatory for listed companies in certain cases. Types of resolution. So now we move to the next topic of resolutions. Section 114, types of resolutions. The resolutions are either ordinary resolution or special resolutions. So ordinary resolutions are passed by simple majority, that is more than 50%. If more than 50% of the members present in voting approve, or more than 50% members Voting, we can remove present word also, considering postal ballot or electronic voting system. So if more than 50% have voted, then if more than 50% votes are received in favor, then the resolution will go if it is an ordinary resolution. But in case of special resolution, is passed by 3 times majority, that is 75%, means of the total votes casted. If 75% of voters are agreeing to go with the resolution, then it is passed as a special resolution. Characteristics of special resolution. So special resolution has following characteristics. Number one is passed by 3 times majority, 75% majority. Resolution shall be set out in the notice. Notice will clearly provide the resolution. Then proper notice of 21 days is given for holding the meeting. Meeting is held by giving proper 21 days notice, 21 clear days notice, which is date of sending is excluded, date of meeting is excluded, so 23 days, plus if sending by post, then 48 hours from posting will be counted as the deemed date of posting, deemed date of sending notice. So 25 days. Explanatory statement should be annexed to the notice for conducting special business. For all special business, all agenda items falling in special business, an explanatory statement is to be annexed. Minutes. Section 118. So resolutions was 114 and minutes is 118. Minutes of the proceedings of the meeting shall be kept within 30 days of the conclusion of every such meeting concerned or passing the resolution by ballot, postal ballot in books. Minutes of the proceedings of the meeting shall be kept within 30 days of the conclusion of every such meeting concerned or passing of the resolution by postal ballot in books. So suppose if a resolution is passed by ballot, then also that will be recorded in minutes in the form of a meeting within 30 days. And if actual meeting is done, then minutes has to be drafted within 30 days of the conclusion of meeting. Minutes book shall be consecutively numbered. So minutes book shall be consecutively numbered. Minutes of each meeting shall contain a fair and correct summary of the proceedings that took place at the concerned meeting. Minutes of each meeting shall contain a fair and correct summary of the proceedings that took place at the concerned meeting. All appointment made at any of the meetings aforesaid shall be included in the minutes of the meeting. So all appointments made at any of the meetings aforesaid shall be included in the minutes of the meeting. Minutes will provide that these appointments were made in the meeting. In the case of board meeting or meeting of committee of board, the minutes shall also contain. So now we are jumping into minutes of board meeting. In minutes of board or in committee meetings, minutes shall also contain the name of directors present at the meeting, and in case of each resolution passed at the meeting, the names of the directors, if any, dissenting from or not concurring with the resolution. So first is who all members attended the meeting. Then before the resolution, that members either all resolution, whether the resolution was passed unanimously or if a director has dissented, then the name will be show up that all the directors voted in favor of the resolution except the directors who did not vote. That should be clearly mentioned. The names of the directors in case of each resolution passed at the meeting, the names of the directors, if any, dissenting from or not concurring with the resolution. So either he says that I have dissented, that will be recorded. He says I am not voting, I am not concurring at this point of time, I require time to think about it. So then he has not voted in favor, his name will appear. Any of the next is any of the following matters shall not be included in the minutes of the meeting which in the opinion of the chairman of the meeting. So chairman, importance of chairman. At times we feel what is the importance of chairman. So chairman is very important person, especially in the drafting of minutes. His word will prevail. So he can remove certain points from the minutes of the meeting. What can be the he can remove following matters to be included from the minutes with the if the chairman is of the opinion. What is the opinion of chairman? That the matter is or could reasonably be regarded as defamatory of any person, that the matter can be defamatory, then also it can be removed. The matter is irrelevant or immaterial to the proceedings. Matter is not relevant, matter is immaterial, it can be removed, or the matter is detrimental to the interests of the company. The matter is detrimental, that particular matter is not going in the interest of the company, and that can be removed. So defamatory to any person, irrelevant or immaterial, detrimental to interest of company, those matters can be removed by chairman of the meeting. Next is the matter to be included or excluded in the minutes of the meeting shall be at the absolute discretion of the chairman of the meeting. So chairman has absolute discretion. What matters should be taken in the minutes, what matters should be excluded from the minutes. It is at the absolute discretion of the chairman. That is the power of chairman. The minutes kept in accordance with the provision shall serve as evidence of proceedings therein. The minutes serve as the prima facie evidence of the meeting. Next topic is dividend. So let's start dividend in our next session. So far we have covered in this video, we have covered quorum, we have covered types of resolutions, we have covered minutes, we have covered types of voting, and we have covered EGM, extraordinary general meeting, notice of meetings, and we have covered shorter notice of meeting and types of businesses that can be transacted in general meeting, special business or ordinary business. So these all we covered in today's video. Thank you.